welcome to WooStream, bringing Willamette to you. Today's conversation features Gilbert Carrasco, professor of law for Willamette University's College of Law. Professor Carrasco will share his research and work around promoting and defending civil rights in the time of COVID. Specifically, he will help contextualize the origins and intensity of the Portland Black Lives Matter movement, exploring a variety of legal issues related to the presence and action of federal agents on the Portland city streets. He will also provide some brief context as to how civil rights have evolved in America. This session is sponsored by the Center for Constitutional Government, which was endowed by a generous contribution from Willamette Law graduate Ken Peterson, class of 1980, and the Peterson Family Foundation. Professor Carrasco, thank you so much for joining us today.
It's my pleasure. And I also want to thank the Peterson Family Foundation for sponsoring this and for supporting the Center for Constitutional Government. And welcome alumni and others. I am delighted to be here with you. And I'm going to review some implications of the recent protests and particularly the federal involvement in them. And what I'm going to attempt to do is to speak at a level that's accessible to those of you who are not civil rights lawyers. And on the other hand, I know that there are some civil rights lawyers with us today, and glad to see you. And so I'll cover the bases, and to the extent that you don't understand anything I say, please feel free to ask your questions. I'm going to be taking questions at the end of the presentation. And if there's a really burning issue that can't wait, I'll entertain them during the presentation. But we begin with the Black Lives Matter movement. And with respect to that, these protests demanded a variety of things because of the abuse of power and the deprivation of rights, particularly by law enforcement. And so these were demands for justice, they were admonitions for change, and they were really insistences on accountability. And that's where we are today. We have seen a lot of protests in Portland. We've made the national and indeed international news with respect to our events here. And of course, these protests involve the fundamental freedom of the First Amendment that nominee Judge Amy Coney Barrett couldn't name. That is the right peaceably to assemble and to petition the government for redress of grievances. This is one of the essential elements of our Bill of Rights. Indeed, it was in the First Amendment to the Constitution, adopted by the states in 1791. And so that is the constitutional backdrop for our discussion today. We see a very unique kind of development during this administration, one that I've never seen before, and I've never really heard of since Eisenhower sent federal troops into the Little Rock, Arkansas schools to ensure desegregation. But I'm going to be focusing on the federal involvement of these protests, or in these protests. And particularly, you might recall the reference to little green men when Russian troops without insignia, without uniforms, in camouflage, sneaked into Crimea in Ukraine and essentially occupied it and took over the government of Crimea. And to this day, that occupation continues. Well, the federal troops that were involved in suppressing protests, first near Lafayette Square across the street from the White House, and later here in Portland, my home city, were very similar to the little green men of Vladimir Putin. This was a very unusual development, and you probably saw at least the footage of the pushing back of the protesters in Washington, D.C., ostensibly for the purpose of allowing the president to engage in a photo op in front of the church, which is just adjacent to Lafayette Square. And that was at the behest of these unmarked federal troops that deployed tear gas and were really forcibly removing any protesters that stood in the way between Lafayette Square and the church. Of course, in this time of COVID, tear gas is quite a dangerous phenomenon. Tear gas has the natural result of eliciting tearing, coughing, nasal drip, all kinds of fluids from the body, and that can, of course, result in the spreading of coronavirus through the different reactions that people have to tear gas. In some cases, people even vomit as a result of having tear gas and the nausea that results from it. In any case, tear gas was used by the federal agents in Portland as well, as were a variety of other techniques of crowd control, most notably rubber bullets. And the rubber bullets that were deployed in Portland by these federal agents actually resulted in substantial harm. In some cases, there were people who were hit in the face with rubber bullets. You may have seen the footage on the news. One young man was hit in the face and thereafter required surgery and was hospitalized for a number of days. There was another veteran, I would say middle-aged veteran, who had a sweatshirt on with large letters, NAVY, and this poor man was subjected to tear gas at basically extremely close range and right in the face, and also suffered a broken bone as a result of the federal agents' actions. He was not resisting. If you've seen that footage, it's particularly striking because he simply took it. He just took the battering by these agents. When he was gassed, he turned away, but they continued to beat him with batons, truncheons, and so forth. And I saw an interview with him, bandaged and bruised and with a broken bone after the fact. There was also instances of federal agents targeting journalists and legal observers. These journalists were clearly designated as such. They had large helmets on that said press. Same with the legal observers that said ACLU, legal observer, on their backs, and they had like vests on with these designations. And these people seemingly were targeted because of who they were. And this resulted in a lawsuit in Portland, filed in federal court. The style of the case was Index Newspapers versus City of Portland. And that case saw an amendment to the complaint whereby the federal defendants were added to the complaint. And thereafter, Judge Michael Simon, the federal district court judge who entertained the case, ruled in favor of the plaintiffs and issued a temporary restraining order against the federal defendants that occurred on July 23rd, 2020. So we have a lot of events that were really quite tragic involving the federal agents in Portland. I want to read from you to you just a paragraph from a letter dated July 14th, sent to William Barr, the Attorney General, and to Chad Wolf, the acting Secretary of the Department of Homeland Security, signed by Senators Ron Wyden, Jeff Merkley, and members of Congress Suzanne Bonamici, my member, and Earl Blumenauer, also representative from Oregon. Quote, on Saturday, July 11th, 2020, a federal agent, whom we understand to be a member of the DOJ, Department of Justice, U.S. Marshal Service Special Operations Group, SOG, deployed at the Hatfield Federal Courthouse in Portland, Oregon, fired a potentially deadly crowd control munition in apparent violation of commonly employed training tactics that direct officers to aim below the head and face area. An Oregonian suffered a resulting critical head injury and since undergoing surgery is now hospitalized. This is 3 days later. This use of force appeared from recorded accounts to be an unnecessary escalation on the part of federal agents. There were many instances where such actions were recorded on videotape, and sometimes they were live streamed on the news. And so this is not speculation. This is not witness testimony that needs to be corroborated by other witness testimony. This is live and in color for all to see. And so I think that the developments in terms of bringing law enforcement to account for unconstitutional actions has really come a long way since we have reached the age of videotape. And I think that this really makes a tremendous difference. In fact, there are many links to videotaped assaults by federal agents and by the city of Portland police and by some state police troopers that were included as links in the complaint that was filed in the Index newspaper's case. So we have a situation where there have been events that have transpired that have led to a lot of injury and a lot of suffering. And no one is suggesting among the protesters that violence or any kind of criminal conduct is acceptable. By and large, the overwhelming majority of the protesters around the country and indeed the world have been peaceful. And in fact, at times, the protesters in Portland were on, I think it was the Morrison Bridge, and they all got down on a knee and maintained that stance for a number of minutes in replication of the events around George Floyd and Derek Chauvin, the person who murdered him. So in any case, I think that the words of Justice Brandeis, going back, I'm sorry, I think I might have touched something, but I'm with you. The words of Justice Brandeis in 1928 in the case of Olmstead versus United States is appropriate to recall here. Quote, if the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of the criminal law, the end justifies the means would bring terrible retribution. Against that pernicious doctrine, this court should resolutely set its face. And I think those words are just as true today as they were in 1928 when they were uttered by Justice Brandeis. We have a situation where law enforcement agents are really out of control. And they're no better than the looters and the the criminal element in these protests, for they also are breaking the law. So what to do about it? Well, there was a case filed by the state of Oregon against the federal presence in Portland. Ultimately, that case was dismissed for lack of standing. The state was deemed not to have standing to sue the federal government for the deprivations of rights that were at issue in the protests. One thing that I should make clear at the outset is that when we're talking about deprivation of constitutional rights, the threshold question is whether the plaintiff, the person harmed or injured, has a right to sue. And specifically, in these kinds of cases, whether that person has a right to sue for compensatory damages, to redress the injuries that he or she has suffered at the hands of law enforcement. So what I'm focusing on today primarily is this threshold question, whether there is a right to sue, whether there is a cause of action in the parlance of lawyers, whether there is a right of action to go into court and ask a federal judge to rule in favor of that plaintiff against the federal defendants for the purpose of granting that plaintiff damages. There is a landmark case that is probably well known to all of the lawyers on the call. And that case is Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, decided by the U.S. Supreme Court in 1971. That was a 6-3 decision, the majority opinion of which was written by Justice Brennan, and significantly a very important concurring opinion was authored by Justice Harlan, the second Justice Harlan. In the Bivens case, the Supreme Court was essentially deciding whether a person could be heard to sue for damages after being rousted from his bed in the presence of his family by federal agents. This was the then Bureau of Narcotics. They came in with no warrant. They manacled Mr. Bivens in the presence of his family. They turned the house upside down. They took him off to jail. They booked him. They strip searched him. They visually strip searched him. And ultimately, they released him without charge. Now, of course, if he had been charged with a crime, this unconstitutional conduct could have been the subject of a motion to suppress the illegally obtained evidence. But this person wasn't charged with a crime. So there was no motion to suppress that could have been offered in his defense. He needed no defense because he was neither charged nor convicted of any crime. The second possibility for redress would be an injunction. But in a situation like this, Mr. Bivens would have had to show that it was likely that the Bureau of Narcotics would have come in a second time and undertaken the same kind of illegal activity, and therefore giving rise to a need for an injunction against this future conduct. Of course, this was highly unlikely. The government knew that it had done wrong. It was not going to do wrong again, at least to him. And so an injunction would have been unavailing. So as Justice Harlan in his concurring opinion said, for someone in Bivens' shoes, its damages are nothing. And that was certainly true. And so the court had to face the question, Should we, the US Supreme Court, recognize an implied cause of action for damages because of constitutional violations by federal agents, notwithstanding the fact that there is no statute conferring a right of action? Now, in another context, if the actions, the unconstitutional actions had been undertaken by state or local law enforcement officers, they could have sued using 42 USC section 1983, the Ku Klux Klan Act of 1871, which confers no substantive rights, but does confer a right of action to sue for deprivation of federal rights, whether they be constitutional, statutory, or regulatory. Of course, 1983 didn't apply in this circumstance because the Federal Bureau of Narcotics employed federal agents. They were not state or local agents, and therefore they were beyond the coverage of Section 1983. This was the main argument that Justice Black, in dissent in the Bivens case, proffered. He suggested, well, Congress knows how to enact such a statute. They did so when it enacted 1983. And if they wanted to provide any protection against federal violations of constitutional rights, they simply could have enacted a similar statute. And absent that, we shouldn't get involved as the courts. The majority felt otherwise, however. And Justice Brennan, in a passage from the case, said this, quote, that damages may be obtained for injuries consequent upon a violation of the Fourth Amendment by federal officials should hardly seem a surprising proposition. The present case involves no special factors counseling hesitation in the absence of affirmative action by Congress. The question is merely whether petitioner, if he can demonstrate an injury consequent upon the violation by federal agents of his Fourth Amendment rights, is entitled to redress his injury through a particular remedial mechanism normally available in the federal courts. And within that quote, there's another quote, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. You probably recognize that quote. It's from Marbury versus Madison, Chief Justice Marshall in 1803. And going on to Justice Brennan's quote, having concluded that petitioner's complaint states a cause of action under the Fourth Amendment, we hold that petitioner is entitled to recover money damages for any injuries he has suffered as a result of the agent's violation of the amendment. And so this was indeed a landmark and iconic decision of the Supreme Court, recognizing that there can be redress directly under the Constitution, even absent a statute conferring a right of action to sue. And so this decision is what is in issue today. This decision is under attack, and I'll explain in more specifics how it's been under attack very recently and recurrently by the U.S. Supreme Court for the last 40 years. There have only been 3 cases since Bivens was decided in 1971 that have ruled that a Bivens action can lie, that one can sue directly under the Constitution for violations of constitutional rights. The first after Bivens was the case of Davis v. Passman in 1979. This case involved the sexual harassment by a member of Congress of a staffer who worked on the Hill, and she sued under the Fifth Amendment of the Constitution for due process violations. The court upheld her suit for damages and found that, yes, the Bivens claim would be heard and she could sue under that doctrine for damages. The second case was the next year, a case called Carlson versus Green in 1980. In that case, there was a federal inmate who suffered from asthma, and the jailers disregarded his plight. He suffered for quite a long time, and ultimately he died. And his estate sued for damages for Mr. Green's death. And again, the court recognized an implied right of action, this time under the Eighth Amendment, the provision that protects against cruel and unusual punishments. And so the Bivens claim remained viable in 1980. The only other case where a Bivens claim has been recognized since 1980 was a case that actually slips through the cracks of the opinions of the various justices on the Supreme Court and is really not mentioned. But there was one other case in 1994, the case of Farmer versus Brennan. Farmer involved another federal inmate, a preoperative transgender inmate who was viewed by the federal district court as particularly vulnerable because of his feminine ways and manner and because of his transgender orientation. Dee Brennan was repeatedly raped in prison, and she ultimately wanted to be transferred to a different male facility, but she was not allowed to do that. And instead, the federal authorities transferred her to a maximum security penitentiary, which is where the most dangerous criminals are held. And predictably, she was subject to more rapes, more abuse. She was made to be a sex slave by one of the other inmates, and she really went through hell before her case was heard by the Supreme Court. And ultimately, with no dissenters, in an opinion by Justice Souter, a cause of action was recognized once again under the Eighth Amendment for the unconstitutional actions taken against Dee Brennan by the federal authorities. So those are the only three cases in the U.S. Supreme Court since Bivens was decided where you have the court recognizing the right of someone to go into court and sue for damages. So what has happened in the interim? Well, what has happened is there have been 8 cases before 2017, before the decision in Ziegler versus Abbasi, which I'll discuss, and 2020, the case of Mesa versus Hernandez, which I'll also discuss, that foreclosed an action for damages in the federal courts by people who are suing directly under the Constitution. For example, the case of Menechie versus Pollard in 2012, the court rejected a claim for damages in a situation involving an Eighth Amendment suit against prison guards at a private prison. In the case of Bush versus Lucas, the court rejected a First Amendment claim against a federal employer. In the case of Chappelle versus Wallace in 1983 also, the court rejected a race discrimination case against military officers. In the case of U.S. v. Stanley in 1987, the court rejected a substantive due process claim against military officers. And in the case of Schweiker versus Chillicky in 1988, the court rejected a procedural due process claim against Social Security Administration officials. And there are actually two more. In 1994, in the Federal Deposit Insurance Corporation versus Meyer case, the court rejected a procedural due process claim against a federal agency for wrongful termination. And finally, in the case of Malesko versus Correctional Services Corporation, the court rejected an Eighth Amendment suit against a private prison operator. Actually, there's one other case, 2007, Wilkie versus Robbins, involving a due process suit against officials from the Bureau of Land Management. So you've got a whole array of different kinds of claims against federal officers or agents for damages. And in each of them, the U.S. Supreme Court said, we're not going to recognize an expansion of Bivens. This became a very substantial problem in 2017 with the case of Ziegler versus Abbasi. Ziegler was the last case argued during the Obama administration. The case was a 4-2 decision because Justices Sotomayor, Kagan, and Gorsuch all did not participate in the case. The majority opinion, the 4-member majority opinion, was authored by Justice Kennedy for the justices in the majority in Abbasi. The Abbasi case essentially established a 2-part test to consider claims under the Constitution for damages against federal officials. The first was whether the claim involved a new context, which could mean any significant difference in the cases that have been recognized under Bivens. That is Bivens, those 3 other cases that I mentioned, any significant difference. And the second criterion was whether there was a special factor counseling hesitation absent affirmative action by Congress. Ziegler versus Abbasi involved 6 individuals who sued various federal officials and officers in the detention facility where they were housed. 5 of them were Muslim, 1 was South Asian. They were rounded up shortly after the 9/11 attacks. They were held incommunicado from 3 to 6 months, and basically were subjected to cruel and unusual punishment, indeed torture. They were subjected to sleep deprivation. Lights were left on for 23 hours a day in tiny cells. Some of them had bones broken, and basically they were without recourse and without any ability to redress their situation during the time of their detention. These people were not criminals, and indeed, during the course of action that these federal officials took, they were actually already known to be innocent of any terrorist activities. But nonetheless, they were retained in detention for months on end in these horrible conditions. With respect to the other situation in 2017, and I want to return to Ziegler, but I want to put this in historical context. There was another case, the case of Hernandez versus Mesa, that was filed in 2015 after a 15-year-old boy was killed by a Customs and Border Protection agent. This boy was playing with his friends in the culvert between Ciudad Juarez on the Mexican side and El Paso on the American side. There's a culvert that goes along the border. Actually, it was once the Rio Grande River. Now At that point, it was pretty much a trickle, but it does vary depending upon the time of year. But the water was low enough at that time that the young man, Adrian Guerreca, was going up to the fence on the American side, touching it and running back. This was the game that he and his buddies were playing on the border. This was irritating to Mr. Mesa, the Customs and Border Protection agent, who was on the American side. And when the young man got back to the Mexican side, he fired 2 shots, the second of which hit Adrian in the face and killed him. His parents brought a suit in federal court against the federal agent involved. The case was described by the U.S. Court of Appeals en banc in the Fifth Circuit. The panel had decided the case partially in favor of Adrian Guerreca. And the U.S. Court of Appeals en banc describes what the panel, the three-judge court, did with respect to this case. And they describe it as follows. The panel opinion correctly describes the substantive due process claim as that Agent Mesa showed callous disregard for Hernandez's Fifth Amendment rights by using excessive deadly force when Hernandez was unarmed and presented no threat. So the Fifth Circuit decided this case per curiam en banc, and that case was appealed to the U.S. Supreme Court. In the first iteration of the case in the Supreme Court, the court recognized in its per curiam opinion that it was undisputed that Hernandez's nationality and the extent of his ties to the United States were unknown to Mesa, the border protection agent, at the time of the shooting. So he didn't know whether he was Mexican or American or Mexican-American. He didn't know the nationality of Mesa at the time he fired those shots. And on that basis, the Supreme Court remanded the case in light of Ziegler versus Abbasi, the case involving the 6 detainees after 9/11. I'll return to Hernandez versus Mesa again because the Supreme Court revisited that case this term in 2020. But before I do, I want to describe for you some of the parameters of the Ziegler versus Abbasi case. Essentially, the Supreme Court was of the view that there could be essentially 7 different excuses that would constitute a sufficiently new context so as to preclude suit in the federal courts for damages under the Bivens doctrine. And these particular elements or factors that constituted new contexts were taken on one by one by the dissenting justices, Breyer writing for both himself and Justice Ginsburg in dissent. And so Ziegler v. Abbasi, again, was a 4-2 decision. And so the first new context, the rank of the officers. If there's a difference in a rank of the officers at issue between the case at hand and the 3 cases that were decided after Bivens, that precludes suit. Well, what does the rank of officers have to do with constitutional violations? Why should that matter? There really is no good reason for that. The second context, new context, is the constitutional right at issue. Well, if the reason for Bivens, as stated by Justice Brennan in that decision, was partially to deter unconstitutional conduct by federal agents, why should the constitutional right at issue matter? And beyond that, there were cases involving the Fifth Amendment under Bivens, and so that right was at issue in Ziegler versus Abbasi. Why the Fifth Amendment in a detention situation? Because these people were immigration detainees. And so the Eighth Amendment doesn't apply to them, the Cruel and Unusual Punishments Clause. So they had to argue that their rights to due process of law were violated under the Fifth Amendment. And so that is the second new context that precludes suit. The third is the generality or specificity of the individual action. Again, if you have a large group of innocent people who are known to be innocent by the federal actors, that should be general or specific enough. Choose your poison. Whatever it is, the actors were known, the violations were known, and all of the allegations, by the way, had to be taken as true because it was decided on a 12b6, a motion to dismiss for failure to state a claim upon which relief can be granted. And so in that procedural context, that is what is necessary for the analysis of the case. The other new context, the extent of judicial guidance. Well, the courts know what the Constitution requires, and the fact that we turn to the courts for judicial guidance in a future case should simply involve the same type of analysis as in previous cases. What is the big deal about the lack of judicial guidance or the extent of previous judicial guidance when you have a constitutional claim that is supported by evidence? The fifth new context is the statutory or other legal remedy or legal mandate under which the officer was operating. Well, the legal mandate is really analytically distinct from the constitutional violation. And if the action of the federal officer goes beyond the legal mandate and involves a constitutional violation, that should not preclude an action in federal court for such violations. The other one, the sixth new context, is the risk of disruptive judicial intrusion. And this is particularly problematic from an analytical perspective. The court in Ziegler and later in Hernandez was of the view that the courts shouldn't get involved because, after all, this really involves something that Congress should authorize, and therefore it's an usurpation of the judicial role to involve itself in declaring constitutional rights and providing remedies without congressional authorization. But when you consider that the federal courts are responsible for enjoining federal conduct nationwide in many cases, what greater judicial disruption does that involve than a suit by one individual for damages? And so this really it rings hollow when you consider what the federal courts are now doing and have done since the inception of the Republic. The last new context is denominated other potential special factors. Justice Breyer doesn't even respond to that because the majority opinion doesn't tell us what these other potential special factors might be. And so we would simply be engaging in speculation as to what Justice Kennedy might have had in mind when he referenced these other special factors. So that brings us to the second criterion, that is the new context, and essentially this litany of new excuses, new contexts that will preclude suit. If that weren't enough, the court says, well, if this case does involve a new context, then they have to go on to consider whether there is a special factor counseling a special factor counseling hesitation absent affirmative action by Congress. Now, this is a very interesting analysis because in the Bivens case itself, they use that phraseology to reference the fact that Congress had never expressed any hostility to the recognition of suits against federal actors without statutory authorization. There had never been a statute prohibiting that. There was never any indication in any federal statute that that should not be undertaken by the courts. And in fact, under common law, the federal courts were there to provide remedies in all kinds of cases. And that's what Chief Justice Marshall referred to in Marbury versus Madison. So it's interesting that this criterion is turned upside down. And now the Supreme Court in 2017 is saying, well, since Congress hasn't authorized such suits, since it hasn't spoken affirmatively in conferring a private right of action, the courts shouldn't get involved and create one. So that's exactly the opposite point that was made by that language in Bivens that now the Supreme Court adopts as a reason for foreclosing suits. And so that is particularly ironic given the original meaning of the usage of that phraseology in the Bivens case itself. The other interesting point that is made both in Ziegler versus Abbasi and in Hernandez versus Mesa in the 2020 decision is that the special factor counseling hesitation absent affirmative action by Congress also includes a consideration of national security. And this is a particularly interesting and somewhat ironic factor when you consider what was actually involved in the cases, both in Ziegler and in Hernandez versus Mesa. The point that is made in Ziegler is that, well, you know, you've got these immigration detainees who are detained because they might be terrorists. Well, not only was it known that they weren't terrorists, but most importantly, the point is that the only things that were at issue in the case were the conditions of confinement. There was nothing about the reasons for the arrest that was involved in the case. There was nothing about the predicate actions that the federal actors might have considered before the arrest. That was not in the case at all. The only issue in the case was whether this torture and unconstitutional treatment should be compensated for. And so national security is a red herring in that case. In Hernandez versus Mesa, I think a similar analysis obtains. In Hernandez, the court says, quote, "We have said that matters relating to the conduct of foreign relations are so exclusively entrusted to the political branches of government as to be largely immune from judicial inquiry or interference." And so the court uses foreign relations and national security as yet another excuse to foreclose a case involving clear violations of human rights. The other thing they say about this issue is the following, quote, since regulating the conduct of agents at the border unquestionably has national security implications, the risk of undermining border security provides reason to hesitate before extending Bivens into this field. So again, this is as if there is an international, controversy. I mean, in fairness, there was somewhat of an international controversy here because you have a sovereign nation invading the space of another sovereign nation and taking the life of someone from that second sovereign nation. That being said, the opinion in Hernandez versus Mesa, and this is the 2020 decision decided just this year, goes into great detail about the act taking place on foreign soil and the question of extraterritoriality, the application of the federal constitution in other countries. Well, the fact of the matter is, Customs and Border Protection agent Mesa was on U.S. soil when he shot the gun. That's incontrovertible. That's stipulated. That's not an issue. And so the question of cabining the actions of federal agents is fair game if that federal agent had taken action on U.S. soil. So the question of this national security or foreign relations issue is really, I think, a red herring. The court has basically said, just like Justice Harlan in his concurring opinion in Bivens, for someone in Bivens' shoes, it's damages or nothing. The family of Adrian Guernica tried to have the officer extradited to Mexico to face trial for murder in Mexico. The United States declined to extradite Mr. Mesa to Mexico for a fair trial. The other thing that was discussed by the court is the diplomatic relations between the United States and Mexico. And the United States took the position that, well, this is a matter for diplomacy. We should work this out. And, for that reason, there should be no consideration of the claim of Mr. Hernandez, the family of Guernica, in federal court. The other question that the court addresses is the actual international dimensions of this. And I think that one of the important aspects of this from an international perspective, if the court is so concerned with international law in this case, they might consider the International Covenant on Civil and Political Rights, which is an international treaty to which the United States is a signatory. And that treaty was ratified by the United States. And in the course of ratification, the United States issued reservations and understandings, which is typical when an international instrument is agreed to by a foreign state. So first of all, the language of that provision says, and I quote, anyone who's been the victim of unlawful arrest or detention shall have an enforceable right to compensation. This is right in the international treaty to which we are a signatory. And beyond that, the reservation that the United States lodged in agreeing to be bound by that international instrument reads as follows. Article 9.5 requires the provision of effective and enforceable mechanisms by which a victim of an unlawful arrest or detention or a miscarriage of justice may seek and, where justified, obtain compensation from either the responsible individual or the appropriate governmental entity. So if we want to talk about international law, let's talk about what the United States is bound by. If we want to talk about foreign relations and national security, let's look at what is actually binding on the United States and not some speculation about some activities in a foreign country that involve extraterritoriality. So this is one of the many things that is raised by this series of cases. So it has been made abundantly clear in Ziegler and in Hernandez versus Mesa that the Supreme Court will not entertain any future Bivens actions until Congress acts. So what should we do about this? And this is where I come in. When I read about this young boy, and he's not the only one, there was another 16-year-old boy who was shot at least 10 times, and he was also on the Mexican side of the border, Rodriguez versus Swartz, the Ninth Circuit case in 2016, shot by a Border Patrol agent in Nogales, Arizona, on an embankment looking down on the Mexican side. And he was still alive, actually, when the 10th shot hit him and crushed his cranium and killed him. But in any case, so this is not a random phenomenon. This has happened many times, and there are reports that document those instances of deaths and murder by Customs and Border Protection agents on the American side, shooting toward the Mexican side. But essentially, after I read the case of Hernandez versus Mesa in a recent decision, I was upset enough about the 2017 decision, but when the 2020 decision adopted the reasoning of Ziegler versus Abazi, which was unclear because it was 4-2, but in Hernandez versus Mesa, it's a 5-4 decision, and Justice Alito wrote the majority opinion, and 4 members of the court, just the usual suspects, Justices Kagan, Sotomayor, Breyer, and Ginsburg, dissented from the majority opinion. And in the concurring opinion filed by Justice Thomas, which was very similar to his concurring opinion in Ziegler versus Abazi, this time he picked up another vote, Justice Gorsuch, in the Hernandez case. Justice Thomas writes that, well, we've basically eviscerated Bivens. We should just overrule it. And so the writing is on the wall, even in the majority opinion by Justice Alito, but Justice Thomas makes it explicit in his concurring opinion. And it's clearly the case that the Supreme Court is not going to hear any compensation cases under the Constitution unless Congress acts. So what to do about this? Well, there is a simple fix, and I am working with our senators, and I'm hopefully going to make a difference in changing the law here, at least if things go the way I hope they do. But in any case, I want to share with you what I have suggested to them in the way of a remedy for this problem. And essentially, it takes the language of the Ku Klux Klan Act of 1871, 42 U.S.C. Section 1983, and simply adds 5 words to that statute. I call this the Federal Accountability Improving Responsibility Act, FAIR, the FAIR Act. And basically, Section 1983 already provides a right of action to sue state and local actors for constitutional violations. The inclusion of the words "of the United States" or simply extends that private right of action to sue federal actors for constitutional violations. And so this particular effort, of course, will go nowhere unless we have a new Senate and a new person in the White House, needless to say. Mitch McConnell is not inclined to entertain anything along these lines, and he's made that clear with some of the bills that have been sitting on his desk for months, if not years. So this is the remedy that I have suggested. This would change the law and provide a statutory hook for such suits against federal actors like those little green men who invaded Portland for damages. And of course, an injunction wouldn't have helped that young man who had to have surgery because of having a rubber bullet implanted in his face. And it certainly wouldn't be relevant to have a motion to suppress because these were peaceful protesters by and large, not involved in any criminal conduct. And so the only remedy, as Justice Harlan says, is damages or nothing. So this doesn't solve all of the problems that face us with regard to suits against governmental officials. And I'm just going to touch on this other issue very briefly, and then we'll open it up to some questions. Of course, one of the other major issues when you're suing governmental actors for unconstitutional conduct is the question of qualified immunity. And qualified immunity is the doctrine that allows for the defendant, the governmental defendant, to get off the hook if it cannot be shown that the violation was of a clearly established statutory or constitutional right of which the officer should have known. And so that standard has yielded a result in most cases, essentially foreclosing any relief because of qualified immunity. Now, there have been efforts to address the qualified immunity side of this. There have been several initiatives. There was a case, there was a bill introduced by Senators Booker and Harris called the Justice and Policing Act that would end qualified immunity essentially and would rectify this problem at least. There's another bill that has been introduced. It's called the Preventing Authoritarian Policing Tactics in America's Streets Act of 2020. That also remains on Mitch McConnell's desk. And then on the House side, there are two bills. Most recently, the End Qualified Immunity Act that was introduced recently in the House. And then another bill that actually passed the House of Representatives in June. It was called the George Floyd Justice and Policing Act. And so there are efforts underway to address this part of the problem. But clearly, to address the Bivens situation and the lack of a right of action, we are going to need a statute enacted by Congress so that we can get some justice when federal actors run amok and cause injury with impunity. So I'll leave it there. I just want to leave you with one thought before I end this formal part of the presentation, and that is a quote from a case called Mitchell v. Forsyth, which was actually a qualified immunity case, but it's apropos of the Bivens concern as well. And this goes particularly to the point of the excuses of national security and foreign relations. This is a short quote. Quote, national security concerns must not become a talisman used to ward off inconvenient claims, a label used to cover a multitude of sins, end quote. So that's really, I think, what Kennedy gave lip service to in Ziegler. He actually quoted that in Ziegler, and yet went on to use national security and foreign relations as an excuse to deny relief. So with that, I'll turn to you, the audience, and encourage you to ask any questions you might have, and I'd be happy to clarify, explain, or defend anything I've said.
Thank you so much, Professor. And I really appreciate the minute detail and timeline you went through when we're looking at how that kind of legislating from the bench idea has also evolved when we're looking at the court's action or lack of action. The first question that we got, it kind of goes back to the Portland situation specifically and public understanding. It is there a distinction between troops and federal law enforcement agents? What impact does the use of these different terms have on understanding what's going on?
Well, that is a very good question. And in the letter that I began with from Senators Merkley and Wyden and Congressman Blumenauer and Congresswoman Bonamici, they actually refer to a variety of units within the federal government that is not the military. They reference the Border Patrol Tactical Units, BORTAC. BORTAC has a reputation of being the most aggressive federal law enforcement cadre in the federal government. They also reference the Homeland Security Investigations Special Response Teams, HSI SRT, the U.S. Marshals Special Operations Group, SOG, and I think that particular group was responsible in large part for the injuries that were incurred at the hands of federal agents in Portland. So these are some of the groups that in the other legislation that I mentioned, the Justice and Policing Act, they also attempt to restrict federal agents' crowd control measures. And there's a lot of good stuff in that legislation, and I hope it sees the light of day at some point.
So, and thank you. Another question that came in, Emily just wants to thank you for explaining the Supreme Court decisions. And in light of those, would you say that at this time, it is true that there is no cause for action for damages against federal officers for unconstitutional conduct?
Justice Thomas and Gorsuch haven't gotten their way yet. There hasn't been a formal overruling of Bivens. And Bivens claims continue to be brought. And until there is a resolution of this question by the Supreme Court definitively overruling Bivens, or by Congress providing a cause of action for damages for constitutional violations by federal agents, I think that we have no choice but to file Bivens actions. I mean, that poor young man who took a rubber bullet in the face, I mean, he has no choice. The only thing he can do is to file a Bivens claim. And of course, he incurred expense. He incurred actual damages through medical expenses. And I'm sure that he has pain and suffering and the like, for which he should be compensated. And, you know, I think it's really shameful, frankly, that the Supreme Court has decided to foreclose claims and render the Constitution, a moot point. I mean, if we can't sue for constitutional violations, why have a Constitution? Why have a Bill of Rights if we can't vindicate our rights under those provisions? And so I think it's a real tragic development in the Supreme Court. This development has really transpired at a very rapid pace since 2017. And in 2020, the writing has been really clearly written on the wall as to what the Supreme Court will do when faced with a new context or a special factor counseling hesitation.
Another question that we have in the chat is, if the local government cannot or will not protect citizens from any lawless behavior, must federal agents be called in, or can individuals act on their own? If they do act on their own, is there any redress potential against them?
Well, this is a difficult question. At some point, I think that the governor did call in the National Guard. But remember, the National Guard is actually comprised of state militia. They are actually under the control of the state, not the federal government, even though this misnomer, the National Guard, is used. And that was in an attempt to, sort of get things under control. In terms of self-help, that's a risky business. And I think that while it is a constitutional right to protest and to assemble peaceably, as the Constitution puts it, that right does have its limits. And at some point, the government can declare a riot, and they can essentially stop people from, overcoming the property rights of businesses in the vicinity and so forth. So I think that if an individual defies an order of a police officer or of a federal officer, that has to be thought through pretty thoroughly. And so it really kind of depends on the factual circumstances and whether indeed there is a necessity for the government officers to be doing what they're doing. And I think that once they go down the road of assaulting people, firing munitions at people and tear gassing people, I mean, that is potentially problematic. And tear gas against civilian populations is actually contrary to the laws of war. And here we are in the United States being subjected to tear gas. So it's a difficult call. I mean, where that line must be drawn is something that isn't always clear. And to some extent, you do have to obey a police order, but if that police order is given with a motive of harassment or obvious retaliation, that may be another story. And in fact, many of the prosecutions of protesters who were arrested during the Portland protests were dismissed. There was no prosecution at all, given that tension and that difficult line to draw.
Okay. We have 3 questions remaining. This next one kind of looks at the bigger picture. It states we're in an age of political demagoguery and political rationalism. Is this a threat to our personal liberty and or the Bill of Rights?
I think it is. I mean, the rhetoric that we are being subjected to as a populace, as a citizenry, as a people, is reprehensible. And, I don't see any other way to call it. I mean, the way I see it, it's indefensible. And it's contrary to constitutional values. It's contrary to what we have in our founding document. And it's incomprehensible that we have, people in authority who have gone down this road. It's just unbelievable. It's very troubling.
Mm. Yeah, please do. The next question is a little bit more granular. Do you know if Hernandez made a claim under the Alien Tort Claims Act? It does seem like, so they're just kind of wondering if you know a little bit more specifics.
Well, the court did discuss the Alien Tort Claims Act, and as this person probably knows, that statute has been really relegated to a very insubstantial role. But the court did very briefly address the Alien Tort Claims Act, and essentially it said that that act is unavailing for the situation that was at issue in the Hernandez case. And I'm trying to put my finger on it quickly. But in any case, suffice it to say that it must have been raised because the majority discussed the ATCA briefly, and here it is, and dismissed it rather perfunctorily. Let's see, it says, that actually is the Torture Protection Act. But I know that the Alien Tort Claims Act was also referenced by the court briefly at one point, and that statute was viewed as inapplicable to the claims that the Hernandez family raised in the case. And I don't want to take more time looking for it, but suffice it to say that it must have been raised. Yes, it says, all it says on this point is just one small passage. Yet another example is provided by the Torture Victim Protection Act of 1991, which created a cause of action that may be brought by an alien in a U.S. court under the Alien Tort Statute, and that's the one that the questioner referenced. Under the Torture Victim Protection Act, a damages action may be brought by or on behalf of a victim of torture or an extrajudicial killing carried out by a person who acted under the authority of a foreign state. Consequently, this provision, which is often employed to seek redress for acts committed abroad, cannot be used to sue a United States officer. And so that's about all they say about the Alien Tort Claims Act. As is predictable, the court is really reluctant to rely on that statute after a case that was decided just a couple of years ago.
The next question, and I think it's a good one because this has been a very heavy topic, heavy discussion. A lot of the people on with us have probably been impacted or know people that have been at the protests and things. It's how do you stay motivated if it takes an act of Congress to change the laws with respect to federal deprivation of civil rights?
Well, these decisions motivate me. After these decisions, I sat down and wrote an analysis with an executive summary and sent it off to Senator Merkley. And I said, this is what we need to do. And his staff has been very receptive, and that of Senator Wyden as well. I think we're going to make this happen, but we have to get a different Senate and a different president for it to happen. Certainly McConnell would not move this forward, and certainly Trump would not sign it into law. So our only hope is for the government to change so that this statute can become law. But I think that, this is worth pursuing. This is doable. If we get a new president and a new Senate, I think this will become the law, and it should. And I think there are a lot of people now who recognize that it should. And this Black Lives Matter movement has really mobilized people and motivated our leaders to recognize that people are demanding change and accountability and justice in our government when federal agents really violate people's rights.
And I think part of that motivation comes from so many folks being able to capture these incidents, to, as you said, all of those different links that were shared with example after example of this action. Is there anything else that you think you'd like to share with those of us who are still on, or to kind of wrap things up, unless any other questions come through? We're getting towards the end of our time here.
Well, just what I've said before. I mean, you should weigh in if you can. If you have contact with our representatives in the federal government, whether it be in the Senate or in the House of Representatives, you should let them know that you are informed and that you are concerned and that they should act. And they are our representatives. And so I think that meetings with them to inform them and to bring them up to speed and to guide them to the promised land, I think that's all fair game. And if anybody wants to do that and wants me to help, I am very willing and able to do that. I'm ensconced in this issue at this point. I'm very much motivated to change the status quo, and it takes committed lawyers like many of you to effect change. And that is what is needed. That is what we've been in the streets for all these months. And although I didn't participate in the protests, other than a lawyer's protest, I support those people who do. And I also recognize that those protests should be peaceful. They should be lawful. And violence has no place on our agenda. We follow in the steps of Gandhi and Dr. Martin Luther King Jr. Nonviolent change. That's the path. I think that we need to work within the system to change the system. We have a good system. We need good leaders to implement that system, and we need good laws to carry it out as well. So I encourage you, all of you, to do your part and, take a role in your government to make it better. And certainly the thing that almost all of us can do, all of us as U.S. citizens can do, is go and make sure our ballot gets counted.
Thank you so much for that. And just so that everyone knows, we'll make sure that they have my contact information. If anyone reaches out, I will forward that on to you. Professor Carrasco, thank you so much for sharing your insights and knowledge on the work being done to defend and promote civil rights at a very difficult, polarized time in our country's history, and the extra complications and complexities added by the global pandemic and that we're seeing. For those of you who've joined us, please continue to check into WooStream. There's more webinars and content, and hopefully we'll continue this discussion around civil rights and other issues as we can. And thank you just so much, everyone, for all of your time. We really appreciate it.
Yes, thank you for your attention, everyone, and be well, stay safe, stay healthy.
Thank you all, everyone. Have a good evening.